I have with me the Yellow Book, New York Family Law Statutes, the 2011 edition by LexisNexis. And I'm looking at page F hyphen 324. On this page, we find section 1039 of the Family Court Act. Section 1039 is about adjournment in contemplation of dismissal. This section has a few parts to it, and it takes up 1, 2, almost 3 pages. I do not see anywhere in section 1039 mention of forcing someone to comply with an ACD by use of force or use of arrest warrants. I don't see anywhere in this section mention of punishment if there is non-compliance with an ACD. Now, I'm not suggesting that I was non-compliant. I'm using the term non-compliant because that's the term the city used at the point. It's not my term. I don't concede that I violated or didn't comply. I believe I completely complied. The proof is in the pudding. The child about whom this case was had 100% school attendance at the time when the city applied for the arrest warrant. They even have it in their case notes that they did a search and found that the child had 100% school attendance. You know, school staff are mandated reporters. So when a child is attending school, the city has an assurance that any suspicion of neglect or abuse of the child will be reported. Right? It's like the government has their own agents in the school looking out. Like staff can at any time pick up the phone and call State Central Registry and report a suspicion of neglect or abuse. So if the child is in school, there's a built-in mechanism for assuring their well-being and safety, at least to the extent that the law is involved, if that makes sense. So back to the Yellow Book, page F324, and I'm looking at let's look at section A. Prior to or upon a fact-finding hearing, the court may, upon a motion by the petitioner with the consent of the respondent and the child's attorney, or upon its own motion with the consent of the petitioner, the respondent, and the child's attorney, order that the proceeding be adjourned in contemplation of dismissal. Hear this. under no circumstances shall the court order any party to consent to an order under this section. The court may make such an order only after it has apprised the respondent of the provisions of this section, and it is satisfied that the respondent understands the effect of such provision. Now, I'm skipping section B. Well, I'll read it so you see what I'm skipping. Section B, an adjournment in contemplation of dismissal is an adjournment of the proceeding for a period not to exceed 1 year, with a view to ultimate dismissal of the petition in furtherance of justice. Upon the consent of the petitioner, the respondent, and the child's attorney, the court may issue an order extending such period for such time and upon such conditions as may be agreeable to the parties. Section C. Such order may include terms and conditions agreeable to the parties and to the court, provided that such terms and conditions shall include a requirement that the child and the respondent be under the supervision of a child protective agency during the adjournment period. In any order issued pursuant to this section, such agency shall be directed to make a progress report to the court, the parties, and the child's attorney on the implementation of such order, no later than 90 days after the issuance of such order, unless the court determines that the facts and circumstances of the case do not require such reports to be made. In my case, the court did not request such a report. I will continue. The Child Protective Agency shall make further reports to the court, the parties, and the child's attorney in such manner and at such times as the court may direct. Okay, so in my case, the court did not direct any further reports. D. Section D, E, and F. Section B. Upon application of the respondent, the petitioner, the child's attorney, or upon the court's own motion made at any time during the duration of the order, if the Child Protective Agency has failed substantially to provide the respondent with adequate supervision or to observe the terms and conditions of the order, the court may direct the Child Protective Agency to observe such terms and conditions and provide adequate supervision, or may make any order authorized pursuant to Section 255 of this Act. 255 of this Act. So, Section 255. That's the Section 255. Oh. Yeah. 255. Cooperation of officials and organizations. It is hereby made the duty of, and the family court or a judge therefore may order, any state, county, municipal, and school district officer and employee to render such assistance and cooperation as shall be within his legal authority, as may be required to further the objects of this act provided. However, that with respect to a school district, an order made pursuant to this section shall be limited to requiring the performance of the duties imposed upon the school district and Board of Education and trustees thereof pursuant to Section 4005, 4402, and 4404 of the Education Law. to review, evaluate, recommend, and determine the appropriate special services or programs necessary to meet the needs of a handicapped child, but shall not require the provisions of a special service or program, but shall not require the provisions of a specific special service or program, and such order shall be made only where it appears to the court or judge that adequate administrative procedure to require the performance of such duties is not available. It is hereby made the duty of, and the family court or judge thereof may order any agency or other institution to render such information, assistance, and cooperation as shall be within its legal authority concerning the child, who is or shall be under its care, treatment, supervision, or custody, as may be required to further the objects of this act. The court is authorized to seek the cooperation of, and may use within its authorized appropriation, therefore, the services of all societies or organizations, public or private, having for their object the protection or aid of children or families, including family counseling services, to the end that the court may be assisted in every reasonable way to give the children and families within its jurisdiction such care, protection, and assistance as will best enhance their welfare. Okay, I don't see how this relates to the case. Okay, so let's go back to section 1039, page F324, section E. Upon application of the petitioner or the child's attorney, or upon the court's own motion made at any time during the duration of the order, the court may restore the matter to the calendar if the court finds after a hearing that the respondent has failed substantially to observe the terms and conditions of the order or to cooperate with the supervising child protective agency. In such event, unless the parties consent to an order pursuant to section 1051 of this act, or unless the petition is dismissed upon the consent of the petitioner, the court shall thereupon proceed to a fact-finding hearing under this article no later than 60 days after such application, unless such period is extended by the court for good cause shown. Letter F. If the proceeding is not so restored to the calendar, the petition is, at the expiration of the adjournment period, deemed to have been dismissed by the court in furtherance of justice unless an application is pending pursuant to subdivision E of this section. If such application is granted, the petition shall not be dismissed and shall proceed in accordance with the provisions of such subdivision E. Letter G on page F325, notwithstanding the provisions of this section, the court may, at any time prior to dismissal of the petition pursuant to subdivision F, issue an order authorized pursuant to section 1027. So let's go to section 1027. Hearings and preliminary orders after filing the petition. It doesn't seem to apply. It's hearing after a child has been named. Section 1039A is procedures following adjournment and contemplation of dismissal. The local child protective service shall notify the child attorney of an indicated report. Section 1039B, termination of reasonable efforts. Letter A, in conjunction with or at any time subsequent to the filing of a petition under Section 1031 of this chapter. 1031. So this relates to the filing of a 1031 petition. So let's see, what's a 1031 petition? Originating proceeding to determine abuse or neglect. Okay, so that's the original neglect petition. In conjunction with or at any time subsequent to the filing of a petition under Section 1031 of this chapter, the social services official may file a motion upon notice requesting a finding that reasonable efforts to return the child to his or her home are no longer required. Okay, so this section relates to when a child was removed from the home. This does not apply. Okay, so the only part of this 1039 that applies to my case is not 1039A, 1039B. Okay. So yeah, I mean, did you see or have you heard anything in this section that says if the respondent violates or doesn't comply with an ACD, the law requires or the law allows that a warrant be issued in order to enforce the order? No, it's nowhere in this section. If you find it anywhere, please let me know. Please do it. That's it for now.